everyone. Today I'm going to explain you the topic public interest litigation. Public interest litigation is also commonly known as PIL. Now, what is PIL? Public interest litigations are those litigations that are conducted as per the common interest of the public in order to solve a grievance. Public interest litigation is not defined in any act in our constitution. It has been interpreted by judges to consider the intent of public at large. Although the main and only focus of such litigations is only public interest, there are various areas where a PIL can be filed. It is litigation which can be introduced in a court of law, not only by the aggrieved party but also by the court itself or by any of the private party. And when a court files a public interest litigation, so it is also known as suo motu. Now, the most common question occurs in our mind is that is PIL adopted or has been discovered in India? So no, PIL has been adopted from the American Constitution. In America, it was designed to provide legal representation to previously unrepresented groups like the poor, the racial minorities, unorganized consumers, citizens who were passionate about the environmental issues. Now, who were the pioneers of PIL in India? PIL has been introduced by P.N. Bhagwati and V.R. Krishna Iyer. P.N. Bhagwati introduced the concept of public interest litigation and absolute liability in India, and for this reason is held, along with Justice V.R. Krishna Iyer, to be the pioneer of judicial activism in this country. In 1998, the Supreme Court formulated a set of guidelines to be followed for entertaining letters or petitions received by it as PIL. Now, these guidelines were modified in 1993 and 2003. According to them, the letters or petitions falling under the following categories alone will be ordinarily be entertained as PIL. Now, some of the scopes of PIL in India are non-payment of minimum wages to workers and exploitation of casual workers and complaints of violation of labor laws. Petition from jail complaining of harassment for premature release and seek release after having completed 14 years of jail, death in jail, transfer, release on personal bond, speedy trial as fundamental right. Petitions against police for refusing to register a case of harassment by police and death in police custody. Bonded labor matters, neglected children. Some other scopes of PIL are family pension, petition from riot victims, petitions pertaining to environmental pollution, disturbance of ecological balance, drugs, food adulteration, maintenance of heritage and culture, antiques, forests and wildlife, and other matters of public importance. The petitions complaining of harassments or torture of villagers by co-villagers or by police from persons belonging to scheduled caste, scheduled tribe, and economically weaker backward classes. And the last one is petitions against atrocities on women, in particular harassment of bride burning, rape, murder, kidnapping, etc. Now let's talk about some of the most famous PIL cases in India that had made PIL a successful thing. First case is Vishaka versus State of Rajasthan. Now in this case, so in Vishaka versus State of Rajasthan case, there was this woman called Bhabri Devi who attempted to stop the marriage of 1-year-old girl in rural Rajasthan. Members of local community retaliated first by harassing Bhabri Devi with threats and imposing a socio-economic boycott on her family, and then on September 2, 1992, 5 members raped Bhabri Devi. Naina Kapoor, the lawyer of Bhabri Devi, who attended the case of Bhabri Devi's criminal trial, decided to initiate a PIL case action in Supreme Court to challenge sexual harassment in the workplace. The Vishaka writ petition was filed in 1992 in the name of 5 NGOs against the state of Rajasthan, its Women and Child Welfare Department, its Department of Social Welfare, and the Union of Government. The Vishaka judgment recognized sexual harassment as a clear violation of fundamental constitutional right to equality, non-discrimination, life, and liberty, as well as right to carry out any occupation. Now, the guidelines directed towards employers included a definition of sexual harassment, a list of steps for harassment prevention, and description of complaint procedure to be strictly observed in all workplaces for the preservation and enforcement of the right to gender equality. It has promoted gender enforcement of women's rights and broader application of international law at high court level. The case has thus been described as the path-breaking, one of the most powerful legacies of PIL case and trendsetter that created a revolution. In Hussainara Khatoon versus State of Bihar case, there was a PIL case that a court was thrown to incredible situation of under trials in Bihar, as there was a lot of people who were still in under trial while in the period of detention. So who are in these now in this case, situation of under trials in Bihar who had been detained pending trials for periods far in excess of maximum sentence for the offence they were charged with. Now, the court not only proceeded to make the right to speedy trial the central issue of the case, but passed the order of general release of close to 40,000 under trial who had been undergone detention beyond such maximum period. So in Javed versus State of Haryana case, government of Haryana has officially disqualified people who to contest election at panchayat level who had more than two children. So the Haryana provision disqualified these people, and the objective of this two children norm was to popularize family planning under the assumption that other citizens would follow the example of restrained reproductive behavior set by their elected leaders. But in the petition and the appellant in the Javed case were individuals who had been disqualified from either standing for election or continuing in the office of panchayat because they had more than two children. Upholding the Haryana provision as salutary and in public interest, the court's main emphasis was on the problem of population exclusion as a national and global issue at the expense of protecting human rights. The Javed decision neglected to evaluate critical whether the contested provision was actually having its intended effect on family planning. The court described the provision as well defined, founded on intelligible differentia, and based on clear objectives to popularize family planning. The other case is MC Mehta versus Union of India case. MC Mehta versus Union of India case was about the authorities, about the civic authorities for allowing untreated sewage from Kanpur's tanneries, making its way to gangs. Now, three landmark judgments and a number of orders against against pollution industries numbering more than 50,000 and in the Ganga basin passed from time to time. In this case, apart from industries, more than 250 towns and cities have been ordered to put sewage treatment plants. Now, 600 tanneries operating in highly congested residential area of Kolkata have been shifted out of the city and relocated in a planned leather complex in the state of West Bengal. A large number of industries were closed down by the court and were allowed to reopen only after these industries set up effluent treatment plants and control pollution. Now, as a result of these directions, millions of people have been saved from the effects of air and water pollution in Ganga basin, covering 8 states in India. Now let's talk about the merit and demerit of public interest litigation. Merits. Vigilant citizens can find an inexpensive remedy because there is only a nominal rate of court fees. Litigants can focus attention on and achieve results pertaining to large numbers of public issues, especially in the fields of human rights, consumer welfare, and environment. In PIL, vigilant citizens of the country can find an inexpensive legal remedy because there is only a nominal fixed court fees involved in this. Further, through the so-called PIL, the litigants can focus our attention and achieve results pertaining to large public issues, especially in the fields of human rights, consumer welfare, and environment. Let's talk about the demerits of PIL. Many people started handling PIL as a tool for harassment because frivolous cases can be filed without heavy court fees as compared to private litigation. Due to flexibility of character of PIL, the opposite party gets an opportunity to ascertain the precise allegation and response to specific issues. PIL is being misused by the public agitations for private grievances in the grab of public interest by seeking public publicity rather than supporting the public cause. Let's talk about the most recent PIL cases in India. One of the most famous cases that we can see are trending these days is between Juhi Chawla and ORS versus Science and Engineering Research. Now, in this case, Juhi Chawla adamantly standed against the 5G technology as, according to her, it will be very much harmful. 5G technology will be a harmful procedure for wildlife and for wildlife like abiotic and abiotic. Indian second case is about Indian Young Lawyers Association and ORS versus the state of Kerala and ORS. The third case is the Karnataka High Court case, who has dismissed a PIL challenging the postponement of the National NEET exam 2021 ahead of 31st August 2021. There was also a very interesting case of PIL was filed against the packaged food and beverages that was also dismissed by the Supreme Court later. So, after this presentation, we came to a conclusion that PIL is a process of putting a public issue before the eyes of law. It is a mechanism that helps the poor get justice. Justice should be granted to one and all irrespective of whether rich or poor. PIL helps in striking a balance between the two case classes to provide justice to one and all. The court must keep an eye on cases being filed and ensure bona fide interest of petitioner and the nature of the cause of action in order to avoid unnecessary litigation. Vexations and mischievous litigation must be identified and struck down so that the objective of PIL aren't violated. PIL, along with other tools like judicial reviews, activism, etc., can be used to attain complete independence of justice machinery. Thank you.